All right, welcome back. Welcome back. I hope you are. We start? Ready? All right, thank you. I hope we're all ready to start. Now we are. We are now at class number, oh my God, 20. Is that right? I think so. We are basically done. We have class today. We have class on Thursday. I am not here next week, so you have 2 blessed days away from me, which I'm sure you all use to do things more important than study for my class, but you'll survive. We have class on the 19th, and then on the 21st, which is I think our last day, I'm going to do a final exam review session. So we are basically at the end of the semester. We are just about done. If you want to meet with me, I would like to do that. I'll be here Thursday for most of the day after class. I'll be here Friday most of the day also. If you want to email me, that'd be helpful. Try and get a block. That's the cutoff for midterm reviews. Of course, I'm available after that to answer general questions or things on your mind, but the midterm review is a little bit more substantive, and I like to have more time to do that. Questions on your mind? Things you're thinking about? All right. All right, let's start with this poll question, which will get us thinking about our next topic. The question is this. Under the police power, a city can require the installation of smoke detectors in apartment buildings. Under the police power, a city can require the installation of smoke detectors in an apartment building. Okay. Go ahead. All right, another 10 seconds or so. Okay. So first off, let's see what we got here. Okay, that's the right answer, right? The right answer here is A. But I want to drill down the why, which is always more important than the what, right? Law students always give you the what, but the why they struggle on. Go away. All right, who's next? Where am I up to? Okay. So we know the answer is yes. That's the easy part. But why does the police power allow the state to require the installation of smoke detectors?
Because the police power is empowered to regulate the policy and general conduct of the people, so installing smoke detectors would fall within the.
Yeah, I mean, that makes sense, right? If you have an apartment building and there's a fire in one unit, that fire can easily spread and harm others. So everyone, I think, would agree that having mandatory smoke detectors promotes public welfare. All right? Now, who's next? Which am I going? Dakota, let me ask you this question, if I can follow up, please. When the government acts pursuant to its police power, is there a requirement to pay compensation?
No.
Okay, why not?
Because it's not an actual taking.
Okay, very good. Very good. Taking and police power are two sides of the coin, right? If you're exercising the police power, it's not a taking. And if you're taking property, it's not the police power. The difficulty with this entire unit is where you draw the line between a police power and a taking. All right? The first case we have today, Loretto, is an instance where the court found there was a taking, but the dissent found that there was not a taking. And we start to see here why this takings unit is so much different from the rest of property, because now we have basically sharply divided Supreme Court decisions where both the majority and dissent view the world in completely different realities. Everyone with me? Okay. So let me take a step back and talk a little bit about how takings operates in practice, right? The first kind of takings we discussed is what's called eminent domain. Eminent domain. Think of the Kilo case, the little pink house from Connecticut. With eminent domain, the government says, hey, Suzette Kilo, we want to take your property, sell it to us or else we'll go to court. Okay, Kilo says, no, I'm not going to sell. At that point, they have to negotiate. Negotiations don't work. All right. Then the government files a petition in court, and they actually hold a trial. And the purpose of that trial is not to decide whether or not they take her house. They can. They will take her house. The sole purpose of the trial is to decide what the compensation ought to be. Right? Kilo's case was unique because she disputed that it was a public use. But generally, when the government wants to take your property, they can do it. All that's in dispute is what they're going to pay you for it. Right? That's what's called, and I'll spell it out, a condemnation proceeding. What's called a condemnation proceeding, where the government tries to condemn your land. And they basically determine what is the value of compensation they'll give you. Right? And there's actually good litigation over what the value of a home is. You might ask, does it include sentimental values? You know, maybe you grew up in that home, you raise your kids there, right? You have a lot of attachment to it. Short answer is no, right? You don't get sentimentality. Do they cover moving expenses? You have to go move somewhere else. Short answer is no. They don't cover the relocation costs. Generally, the cost that they give you for the compensation is going to be the market value of the house. Which, by the way, is hard to calculate because if the government is condemning property, by definition, it's not very valuable, right? They're condemning because they want to turn it into something that's more valuable. So the price they give you is not based on what will this land cost when Pfizer builds next door. It's what's the value now in its currently depressed economic state. So the values that you get at these sort of condemnation proceedings are going to be on the low side, right? They're not going to be anywhere close to what you think your home's worth, what you can get in the market for it, or in the case of Suzette Kilo, what her sentimental attachment. Yes, Andrew?
Arguably, wouldn't you want to be the first person to, like, if there's a big, like, say they're building Cowboy Stadium around town.
Yeah.
You don't want to be the last person to sell your house, right? You want to be the
Oh, I disagree. Who gets the most money for negotiation purposes, the first or the last?
Yeah, okay, would be the last.
You want to be the holdout,
Yeah.
right? Think of it this way, right? Generally, the government negotiates with people and say, okay, let's just say, you know, there are 2, 4, 6. There are 6 people in your row, right? If Tony's the first guy to sell, and let's say he sells for $100,000, right? Then Andrew says, okay, I'll tell you what, you really want this block? Make it 125. And then Kyle goes, oh, you gave him 125? I'm going to take my time. Give me 150. What? What do you want?
I said 1 million.
Okay, he says 1 million, all right? All right, what Hannah says 2 million. Laura says 10. You say, give me 50. Jerry, you know, give it up, right? It's not Jerry, but you know, whoever it is in Arlington. The holdout problem is real. The last person to sell out usually gets the most because he's holding up the entire deal. Because if they need this entire block to build a construction and Andrew's the last one holding out, they can't dig until she agrees to buy it. Now, of course, if she doesn't negotiate, then they go to court and they can just basically get nothing for it. But the litigation can be held up for years, and they want to start building Cowboy Stadium right away. That make sense?
Yeah, well, I mean, that's in terms of settlement, if you're gonna look at just in the case, like if they're gonna value the houses on their own.
I would say, so you're saying that if it actually goes to litigation,
Yeah, because then the value of the house, like there's nothing around you, you're kind of in this.
oh, I see what you're saying. So because you're the only house in the block,
Yeah,
oh, what you're saying is with negotiation, holding out gives you more money, but with the actual just compensation determination, if you're the last one on the block who's standing, then it's even less.
yeah.
That's a good point. Yeah, I hadn't thought of it that way. It's a good thought. Maybe. Yeah. So I guess it's you have to hold out long enough until they go to court, because once you go to court, you get screwed. Is that so? You're getting at? Oh, I see. Yeah, I think that's an astute point. Yeah, Stephen.
If you could hold out long enough, you'd say, I have a great view of the stadium from here.
Yeah, charge for parking on your lawn. Yeah, I'm sure Jerry would love that. Jerry Jones, the Cowboys owner, if you don't know Jerry, keep talking about. I've not actually been to the stadium. It just looks ginormous from the highway. It just looks just huge. All right, so if I can get the way the condemnation proceedings work, and again, it's sort of a chicken dance, whether you accept their negotiation or you risk going to trial where you're probably going to lose out even more. I think you raised a good point, right? What was that movie, Aaron Brockovich, right? Where like people settle, like in the neighborhood, there was some sort of chemicals nearby, and people have to agree to a settlement, and the last one usually gets like the most. Anyway, all right. That's what's called a condemnation proceeding. And this is like in the Kelo case. But there's something different, which is what we have in the Loretto case, what's called inverse condemnation proceeding. Inverse. And this is a phrase the book never actually explains, but I want you to understand how this works. Inverse is the opposite of condemnation, right? With condemnation, the government says, we want to take your property, and here's what we're going to pay you. We only litigate over what the compensation is, right? In other words, we want to use the power of eminent domain to take your land. We want to use eminent domain to take your land, and we're going to pay you something. We'll let the judge figure out what we're going to pay you. The second category is the opposite. Inverse condemnation is where the government says, no, 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 no. We are not taking your property. We are enacting a police power regulation, right? We're not taking your property. We're simply exercising our police power, right? We're making you install smoke detectors. Therefore, we don't have to pay you a damn penny. But the property owner, Ms. Loretto, says, no, you're calling this a police power regulation? I disagree. This is, in fact, a taking. And because it's a taking, you have to pay me, right? It's not the government condemning Loretto's property. It's Loretto saying, you are condemning, but you won't admit it. It's the inverse of condemnation, right? It's the opposite. With condemnation, the government is the moving party. With inverse condemnation, the property owner is the moving party. Ms. Loretto went to court saying, you are taking my land by making me put this little wire on the side of my building, right? The key factor is who's actually bringing the suit. And you need to keep this in mind for the exam. With eminent domain, the government says, we are taking your property, we're going to pay you for it. We'll just debate what we have to pay you. With inverse condemnation, the government says, we're just regulating police power stuff. We're not taking your land. And because we're not taking your land, we don't have to pay you. The property owner says, yes, you are taking my land. I'm going to court to seek just compensation. But note what happens here. Loretto is not saying that you can't put the wire there, right? No one's saying that the wire has to come down. All she's saying is if the wire is here, you have to pay me. Bottom line is, you can't stop the government. All you can do is make them pay, right? You can't tell the government, stop, you can't put this wire up. All you can say to the government is pay me for this wire. Everyone see where you understand the difference, right? The entire purpose of both of these, condemnation and inverse condemnation, is to get payment, right? But the difference is who is seeking the payment. In the first one, the government admits they have to pay. And the second one, the government says, no, we don't have to pay, right? Why does the government not want to pay with the second category? It's expensive, right? Every single now apartment complex in New York City has to have these cables installed on them. And for every one, there might be compensation. Now, we know ultimately it's like $1. It doesn't really matter, but that's still $1 they might not have to pay otherwise, right? If every single apartment building in New York City has to have a smoke detector installed, and the government has to pay every property owner for installing that smoke detector, that's a lot of money. In fact, the requirement of payment inhibits the police power. Put this bluntly, buildings might be less safe if the smoke detectors require compensation, right? Because they say, government says, well, you know what, screw that. We don't have enough money to pay all these people. You're on your own, guys. You're on your own. We're not going to require smoke detectors, and that can impact public safety. All right. Everyone with me? Okay? The remainder of the topics, our class today, Thursday, and also next week, these are all inverse condemnation suits, which are generally brought. Oh, actually, Hadacheck's an outlier, because Hadacheck's a bit of a wrinkle, but at least Loretto and Horne are inverse condemnation in nature, in that they're seeking compensation from the government for taking their property. The government says, no, we're not taking your property. And the property owner says, yes, you are taking you're taking my raisins, right? You're taking my, the land outside of my building with the wires going. Okay. Everyone get this, right? Okay. So the first case we have is Loretto. And actually, Alexis, you want to give me the facts, please, on Loretto?
Sure.
Thank you.
So Loretto purchased a 5-story apartment building in New York.
Mm-hmm.
And the New York law provided that the landlord must permit a cable television company to install its cable facilities upon the property.
By the way, CATV is cable TV. That's what it stands for. Yeah, good.
And then even previous owners of the building granted permission to install the cable on the building. But then there was New York law that passed that said that a landlord may not interfere with the installation of the cable TV facilities. And so Loretto then brought a suit alleging that the installation was a taking without just compensation.
Okay, very good. Thank you so much. A little bit of history. Cable TV was something of a novelty in the 1980s. Today we all have, maybe satellite dishes, or we have, fiber optic cables, right? Where either you have cables that are under the ground or on the telephone poles, and we use those to connect to watch channels, now get internet access. Back in the 70s and 80s, that infrastructure did not exist. In fact, the cable TV companies were in direct competition with the phone company, AT&T. And the phone company did not want to put cable wires along their lines. And the cable companies could not afford to dig and put cables under the ground. So a lot of the cable companies had this, this sort of temporary solution. Think of like Spider-Man, right? Where you have an apartment building and then an apartment building next to it. You would put you put a cable up one side, cross over to the next house, come down. And so you'd have a cable coming down the side of a building, and each window who wanted it, you'd actually have a little offshoot to go into that house. This sort of piggybacking system only worked if you had every house on the block wired. Let's say there were 5 apartment buildings in a block, and Kyle over there said $1 million, right? The house in the middle didn't have the wire on it. The entire block would be dark because you couldn't have the remaining other houses connected to this category, to the cable TV wires. Okay, so New York has an idea, right? New York enacts a law that says that landlords must permit cable TV companies to install cables on their facility. And you have to put this box on the roof, which is all the equipment, and then install this little cable, which is about, a ½ inch in diameter. I mean, like this. It's very small. It's not very big, but about 30 feet in length down the side of your building. You would actually have to nail these wires into the wall. Okay. The landlord will be given a one-time fee of $1 as compensation. Josh, why do you think the state gave people $1 compensation for installing these cables?
To say that they, paid just compensation.
Okay, now I knew you were going to say that. Do you think the state would concede that they were taking property here?
No.
No.
They're going to argue the police power.
Yes, but then why do you have to pay for an exercise of the police power? Do you have to pay for an exercise of the police power?
No, you don't.
So then why'd they give everyone $1?
That's a good question.
Javier, why'd they give everyone $1?
Kind of like a belt and suspenders approach.
I think I know what you're saying. Just finish it up. What were they afraid of?
They were afraid that someone would say it was a taking. So they're like, oh, even if it was a taking, they install it.
Yes, exactly. Perfect. Right. I like that, belt and suspenders. They were the city was afraid that maybe they might lose in court one day. And if they lost in court one day, they'd say, oh, well, okay, gee whiz, it's a taking, but we're already compensating $1, leave everything as it is. Right? They were basically covering their own butts. Right? Because in the event that they lost in court, they would argue retroactively that the money given, the $1 given to Loretto, was in fact the just compensation. They basically made that number up. But generally in the law, $1 is what we call nominal damage, right? Nominal damages. Because really, what is the damage to Miss Loretto? You have this little half-inch cable on the side of her building, right? It's hard to measure exactly how damaging that was, but maybe $1 is enough. Possibly the court might say it's $100, in which case they have to pay more, but they're trying to at least act in good faith, that they weren't trying to harm people with that property. But I think Josh and Javier are correct. They did not concede this was a taking. They could not do that. If they did concede it was a taking, then they got it backwards, right? Because if this was a taking, they'd have to first go to court and condemn every single building in New York City. In other words, they have to choose door number 1, right? They'd have to use a condemnation to condemn every single building, say, we want to install this wire. Versus door number 2 is take first and ask for permission later, right? We just say install the damn thing and then wait to get sued. Right? So you can see why the government likes door number 2. They can just act and then wait to get sued by Miss Loretto, versus with door number 1, they have to go sue Miss Loretto and seek a condemnation against her. Okay, everyone understand just the framework of how this litigation proceeded. All right. All right, so Miss Loretto owned a 5-story building on the west side, and she objected to the installation of the cable. So she brought what's called a class action, which you probably have heard of. A class action is where a lot of property owners bring a claim together and they assert similar common issues. In this case, that the installation of these cables amounted to a taking. The New York courts ruled that there was no taking, but even if there was, maybe the $1 is enough. We don't have to resolve that now. The Supreme Court reversed on an inverse condemnation theory. All right, I got to give you some terminology now. The first term I have to give you is what's called a categorical taking. Okay? A categorical taking. What does it mean to have a categorical taking? The phrase categorical is used a lot in the law. And what categorical means that if something fits within certain conditions, it automatically is a taking. In other words, there's no balancing. We often have in law what are called Brightline rules, and we have what might be called balancing tests, right? Balancing test means, well, there are these 3 factors, and we look at this, and we look at this, and we sort of just balance them out, right? There's a lot of subjectivity. There's a lot of judgment, discretion, if you will, about whether something is a categorical taking. I'm sorry, whether something's balancing. Balancing test. I misspoke. But with categorical takings, there is no balancing. It's automatic. If you fall within this first category, categorical takings, the judges have no discretion. It's automatically a taking. In our readings for Thursday and next week, we'll deal with balancing tests, where the judge sort of measure how much harm is caused versus what the public good is. These sort of wishy-washy tests, which I don't like very much. The categorical test, the Brightline rules, are easy to apply, right? There's no doubt when there's a categorical taking. Horne as well, the raising case. It's categorical. It's easy. You're going to like these easy tests. When we get to the balancing tests, there's a lot more discretion for the judges, and they split in many which ways. Okay, so everyone get the general difference between a categorical taking and regulatory taking. By the way, it's called categorical because if the facts fit within a certain category, with a certain group of facts, it's automatically taking. So once you're in that category, you're home free. Okay, let me add one more word. It's not just a categorical taking, but it's a categorical regulatory taking. Regulatory taking. Why regulatory taking. Because the government is not actually taking your land in the literal sense. It's not like Kilo, where they're demolishing your home. They're merely regulating how you use your land, right? Loretto kept her apartment building. She didn't have to give it up. Rather, Loretto's land was being regulated in a way she didn't like, that they put this little wire in the side of her house, right? You need to keep in mind these different terminologies. You have categorical takings, you have regulatory takings, you have balancing tests. You have different labels, and the courts are not always consistent with how they call these things. They may just say this is a regulatory taking, or they may say it's a categorical taking. But at least from your perspective, understand what categorical means and what regulatory means versus these balancing tests. Okay, come on with me. Yes, Andrew. Well, each word's different, right?
Well, I mean, for that.
Regulatory means you get to keep your land, but the government's regulating how you use it, right? With Kilo, they said we're demolishing your house. We're taking your house. Whereas with the regulatory taking, you get to keep your land subject to some new regulation from the state. Does that make a little sense? I know the terminology is a bit fuzzy, and the courts don't always use these terms consistently, so you may see them in different fashions. But this topic is broadly called regulatory takings. And regulatory takings can be either categorical or subject to a balancing test. And within the balancing test, there's some exceptions also. So I don't want you to think this is so simple and straightforward, but at least you have to know what the terms are. Make sense, Andrew? Okay, very good. I think Jasmine, you're next. Jasmine, walk me through the majority opinion in Loretto. Specifically, does the court find that the installation of these wires is a taking?
Yeah, they find that it's a taking because it was a permanent, it was like a permanent occupation of the property. So because it's a permanent occupation, then it will.
Oh, yeah. Okay, so we have this phrase, right? Okay. Permanent occupation, right? Permanent physical occupation. I think that's the phrase the court uses. Permanent physical occupation. Jasmine, what does that phrase mean? You just said it for us a minute ago. Permanent physical occupation. Yeah, but try defining without using those words. What does physical occupation suggest without using the word occupy? Okay, the use the land, that's good. How does the wire here use the land? Let's try that. Okay, so we're talking about a 1 inch or half an inch wire, about 30 feet in length. Can Ms. Loretto use that half inch strip for any other purpose? No, but subject to this law, could she remove the wire and use that half inch strip? I don't know, a Christmas light or something, I don't know, something else. So how has this 1 inch wire affected her bundle of sticks, so to speak?
She's arguing that it takes away from her bundle of sticks, like it
Good.
takes away her right to exclude.
Yes. Okay, very good. Thank you, Jasmine. We talk about improperly this notion of the bundle of sticks, which is not a real thing, but it's helpful to think about. And the bundle of sticks describes the sorts of rights and relationships we have to property. And we say that the most important stick in that bundle is the right to exclude, right? Remember the Jacques versus Steenberg homes? Remember the trailer that went through the snow? Remember this one for property one? Stafey shack with the migrant workers. Okay, I know you read this one. It's in every case book. Okay. The most important stick in the bundle of rights, we say, is the right to exclude. This law takes that stick out of her bundle. It requires Loretto to allow the cable company onto her property, right? That they're actually occupying her land. Now, again, it's a tiny little bit. You know, a cable this width, half an inch, you can barely even see it from the street. But it's occupying her property. If she wants to sell this property, she must now sell it subject to this restriction. If she wants to use it for some other purpose, too bad. She can't put Christmas lights there. That's a spot where the wire goes. The court uses this phrase, permanent physical occupation, to give a bright line rule, right? If you have one of these permanent physical occupations, you have a categorical taking. In other words, the definition of what a categorical regulatory taking is, a categorical regulatory taking, it's a tongue twister, is the permanent physical invasion. I'm sorry, I did it wrong. The permanent physical occupation, it's a tongue twister. Permanent physical occupation. This is the definition of a categorical regulatory taking. This is harder than it looks. These are tongue twisters. They really are. Right? The court gives this bright line rule of defining it. Now, there's some difficulty here, right? Katie, let me ask you a question, please. What does it mean for something to be permanent? Permanent.
I guess you can't take it away.
For how long?
Indefinitely?
Forever. Will that wire be there forever?
No.
Why not?
I mean, I'm assuming they'll change it eventually.
Yeah, technology moves pretty quick. I'm pretty certain, and maybe they're there, I don't know, what do I know? But does permanent mean forever, forever, forever?
Not in the context of the, it does mean permanent in the context of the case.
So maybe like foreseeable future unless something changes? Okay. So you can see how this permanent physical occupation standard gets a little bit dicey. Katya, let me ask you a question. What is the sort of opposite of the permanent physical occupation? What's the other term that the court says is not a taking? They give this other term that's sort of funny.
The temporary physical occupation. Well, here it says what is it?
Not occupation. Yeah, what temporary physical. You were really close to the last word. You got wrong. Not occupation. What's short of an occupation?
Invasion.
Yeah, that's it. Invasion. Thank you. So, Katya, I'll ask you, what on earth is the difference between a permanent physical occupation and a temporary physical invasion? What's the difference between the two?
Would it have to be, well, of course the time period.
Time, good.
Also the time period in which the person owns the property and is required for the cable or thing to be on the land.
Good. Right. So a couple things that I think you said correctly, right? The first is the time frame, right? Permanent suggests forever, although nothing's really forever. Everything has a time limit on it, but at least for the foreseeable future, unless the law changes. Temporary suggests something less than that. Does that mean days? Does it mean weeks, months, years? I don't know, but something less than that. And then the second difference is between the occupation and invasion. And frankly, it's the same idea, right? An occupation is long-term, and invasion is short-term, right? So the court simply adds two words to mean the same thing, right? It's not very helpful. But the distinction turns something on duration of how long something lasts for. We have, though, this sort of game, right? Tyler, let me ask you a question, please. If you are a property owner and you want to get compensation, which category do you want to be in? The first one or the second one?
Permanent, yeah, the first one.
Why do you want to be in the first one?
It's a taking. It's
Automatic, right?
Right, correct.
There's no balancing.
Categorical, right.
And you get paid.
Yes, sir.
Okay, if you're the government, which category do you want to be in?
The latter,
Yeah. Why?
because you don't have to pay.
Okay, very good. The entire game of these sort of takings is which category do you fall into? One or two, right? That's why you call it categorical, right? If you're in category number one, it's automatic. The government's got to pay you. If you fall in the category number two, the government does not have to pay you. Everything in this topic of categorical takings is which category you fall into. There's no discretion, right? It doesn't matter that the taking is only half an inch wide, which no one even cares about, right? If the government, basically occupies your home for a short period of time, and it's only a temporary invasion, they don't have to pay you anything. If the government puts a little cable on the side of your building with a hammer and nail, then they have to pay you for it. Okay? So how then do you draw the line between permanent physical and temporary physical, right? Robert, how do you draw the line, or where does the court draw this line, Justice Marshall?
Between temporary and permanent?
Yeah. What makes this a permanent occupation? What's the deciding factor?
Isn't it that in the terms it has to run so long as the cable or the TV company wishes to retain the installation?
Well, time is certainly part of it, but what's the deciding? How does Marshall know that this goes on permanently? What about this installation really matters? Right. What about this means it's probably not coming down tomorrow, right? What about this gives it some permanence? Think logistically, right? How are these things installed? What was done to the building?
They have to be installed on top.
Again, what does that mean to be installed? Just give me the
It's
detail.
fixed there, can't be.
Fixed by what means? I mean, just how is it fixed? I mean, you're right, but just tell me, how is it fixed? I heard someone whisper it. Yeah, hammer and nail. Okay, fine, you got it. This is permanent for the court because it's literally installed, right? It's installed with tools and hammers and nails, right? You have these silver boxes that are drilled into the ceiling or drilled onto the roof. This is going to sound really stupid, but the test that I always tell my students is, was there hammer and nail involved, right? Was something actually hammered into the wall? If it was hammered into the wall, it's probably going to be permanent. If it's sort of just, lying around, temporary. I know that sounds ridiculous, right? That the entirety of the taking turns on, was this physically installed? Yeah.
How do we square this with the question at the beginning of class with smoke detectors?
Oh, I'm getting there in a few minutes, I promise. The Dissent by Justice Blackmun raises that exact point. I promise I'll come back to that in a minute, right? Is something physically installed? Now, there are other cases involving flooding, right, which the court discusses. And this is one that's very near and dear to us in Houston. When the government floods your property and the water is there for some period of time, is it a temporary physical invasion or a permanent physical occupation? So let's use Houston for our example. Right, when the city of Houston decides to release, or not the city of Houston, but the Army Corps, the federal government, release water from the various reservoirs and dams, Addicks and Barker, and you now had a 8-foot pool of water on top of your house, and it was there for, I don't know, like 4 or 5 days. Was that temporary physical invasion? Or is that a permanent physical occupation? Now, if permanent means forever to infinity and beyond, right? It's not. I mean, nothing's till infinity. I mean, you can't go beyond infinity, sorry. You can't. But can something be there for a few days and still be considered permanent? Well, nothing was nailed in. So the courts are litigating this issue now, and I don't quite know where they're going to come out. Yes, Jacqueline?
Oh,
guess I just got confused because in the opinion it talks about without burdening with the cost of buying or maintaining. So that kind of came into my mind as responding to the flooding, because if you had to fix your property, if you had to resolve this 8-foot pool of water by fixing your property,
There-
then
yeah.
that would be considered a permanent.
There are a lot of cases on taking in which there was one case where this one person's home was flooded many times. So it was like a lot of short-term floodings. And courts have said that many short-term floodings amount to a permanent physical occupation. Where the Harvey one, I think, is a little bit different, is that this had never happened before. It was like a one-time deal. The government has actually argued they get, remember in torts the one bite rule with a dog, right? If a dog gets one free bite, they can then, they don't put down the dog. The government's argued that for flooding, they get one free flood, right? I know that sounds awful if you lived in this area, but this was a disaster, never happened before. They didn't know what to do. They did it. And they promised they won't do it again. Maybe next time they'll argue something different, but they get basically a one free flood rule. I know people are wincing. Yeah, that's the argument the government put forward. Okay. So we can get the distinction between permanent physical and temporary physical, right? I did it before. I said occupation rent invasion. Try to keep these terms straight for your exams. I know they're really easy to confuse. Like an occupation means they stay around for a while. Invasion is just like, the initial force that comes in. They're very similar concepts. But the court finds that when you have this permanent physical occupation, it gets rid of the right to exclude, right? The right to exclude is this important stick in the bundle. And when you're in this first category, you're always a regulatory taking. Other examples beyond flooding or airplanes, right? What happens if you live in the flight plan of an international airport and you also have planes going over your air rights? Well, the planes go over your house for sure, but those are short-term disruptions, right? Plane goes for a few seconds, disappears. But of course, if planes are coming over your house all day long, it becomes sort of permanent. But the courts have upheld the flight plan disruptions. This is not rocket science. It's not something that's very precise. And the court's opinions are not always consistent in nature. Okay. Now, why does the court adopt a Brightline categorical rule? They don't have any line drawing issues. It doesn't matter if the cable is 1 inch or 100 feet, right? What matters is there's some physical occupation, and that's all that matters. Okay. Brianna, but now we get to the question that Matt asked me a minute ago, which is about smoke detectors, right? The court at the end says, look, the government can still require landlords to comply with building codes, right? Smoke detectors, fire extinguishers. I always raise this one, whoever lived in New York. Mirrors and elevators. Do you know why those are installed? Yes, tell us why you don't die.
Because people can hide in the
Yeah, see, you've lived in a city before?
I had a friend who lived there and I went to visit him.
Yeah, okay. So if you ever go into an elevator and you see a mirror in the corner, the reason why is because someone might be standing in front of the buttons and then they rob you. It's a very easy place to rob you because once you get in, you pull the plug, you rob them, and you get the next floor. Anyway, so this is a test of whoever's lived in a city, or at least maybe New York. But you have certain things that are installed that are physically installed. You have to drill a mirror into an elevator, right? You have to drill a smoke detector into a wall. You have to put those little fire extinguisher, I don't know what you call them, like the little holder thingies, into brackets. Thank you. Yes, put the brackets into the wall. So Brianna, has the majority sort of discussed these sorts of building codes? Why are you allowed to require the installation of smoke detectors and fire extinguishers, but not cable TV wires?
Because the fire alarm it's benefiting the greater good of the public. It's for the public safety.
Good.
Cable TV is just for entertainment.
But Brianna, isn't the public welfare very broad? Doesn't include the welfare of the people, and don't people need access to community TV and these other sorts of information?
I mean, they might want it, but it's not a necessity to.
Yeah. Brianna, I think you're giving the exact right answer, but historically, has the court second-guessed the government about what's in the public interest? Historically, do courts second-guess the government about what's in the public welfare, what's in the public interest? Louder. You're right. No. This case is a bit of an outlier on that front, right? Generally, we have a posture of deference. Whatever the government says in the general welfare is in the general welfare. Justice Marshall perhaps realized he was a bit of a pickle because Justice Blackmun makes this point in Dissent, I think, fairly effectively. By the way, no relation, spelled differently. But Justice Blackmun's like, what about smoke detectors, right? Isn't that a taking? So they have to basically make up a distinction. Well, cable TV is different. That's not a good distinction because the public welfare is quite broad. Indeed, one of the requirements of cable TV is to have public access television, right? You don't even know that. Wayne's World, you ever saw the movie, right? The cable TV providers are required to give regular folk access to a certain number of hours a day on the air. And that was meant to let the people speak to the masses. No one ever watches this crap, but I mean, it's on TV, right? And in fact, this very much was for the public welfare. So I think that part of the court's opinion is a bit difficult. Okay. All right. What about then the compensation, Gabriella? What about the compensation? Does the court say that the $1 is enough? What does the majority say here?
Oh no, they said that the taking of the property does not presuppose that the fee is a proper measure of the value of the property.
Sorry. Sorry.
Couldn't find you.
That's confusing. I'm sorry. So was $1 enough?
No.
What did the court say? Did the court rule on the question?
No,
What?
they said that they expressed no opinion.
They expressed no opinion. What does that mean? They expressed no opinion. What does that mean?
Matter for the state court.
Yeah, very good. Thank you. The lower court found there was no taking. Therefore, there was no need to decide if the $1 was appropriate compensation. The Supreme Court says, okay, not our problem. We don't have to do that here. Remand. Send it back down to the lower court and let the lower court decide if the $1 was appropriate compensation. And indeed they did, right? Belt and suspenders, right, Javier? Right, all this for nothing, right? At the end of the day, Loretto got exactly what she already had, which was $1. What was that, Morgan? Yeah, Miss Jean Loretto in every law school casebook for the last 50 years, right? So I guess it's an important case. I like it. It's an important property decision. But at the end, they got absolutely what they had before. They didn't actually, the principle, they prevailed, right? And they actually were victorious. So I'm happy Loretto did this, that she got her name in my property casebook, that we get to teach her case every year, but she got no extra money. Okay. Questions in the majority? I'll do the dissent in a minute. Okay. The dissent by Justice Blackmun ridicules it and says, look, this is ridiculous, right? Who the hell knows what the difference is between a permanent physical occupation and a temporary physical invasion? I'm sure many law students are saying, I agree, Justice Blackmun. I don't know what the difference is. And he's not wrong, right? He says that this approach is misguided and dangerous, and it undercuts the legislative judgments about landlord-tenant relationships. Okay, it's a puny distinction. He also says nothing is actually ever permanent, right? Nothing lasts forever. Everything eventually ends. And you have all these other examples of peepholes, locks, windows, doors, lights, fire escapes, sprinklers, right? Things that landlords are required to maintain that don't fit within this sort of ruling, right? It also shouldn't matter whether the building owner or the tenant owns the property. It really should make no difference. Okay. Questions on the dissent? All right. Loretto is a very important case because it provides a bright line rule, right? If you make into this first category of having a permanent physical occupation, you get paid. If you merely have a temporary physical invasion, you have an exercise of the police power, you don't get paid. So all the litigation is deciding what bucket, which category you fall into. If you're in category number 1, you get money. If you're category number 2, you get bupkis. You get nothing. Deciding which bucket you're in actually can be quite difficult when you don't have something simple, right? When you have a hammer and nail, it's really straightforward. But when you have, flooding for 5 days in Harvey, it's not so clear where you fit. Yes, sir, Stephen.
When you say you get paid, does that also include maybe attorney's fees and stuff like that?
I don't think so.
Government doesn't pay attorney's fees?
The short answer is attorney's fees are usually awarded by statutes. And so in some cases, Congress has approved of attorney's fees in certain types of civil rights actions. I don't know if in inverse condemnation cases you get attorney's fees paid. I'm not sure.
It just seems like if you only get $1 for your efforts, like yeah, you win morally, but
I don't think there's any fee shifting in this case. I might be wrong, but I'm not sure. It's a good question. Lawyers always ask, how do I get paid? Right? That's what lawyers always want to know. I don't know if there's any fees involved in inverse condemnation cases. I'm not sure. I'll check on it later. I'm not sure. Okay. Is there any questions in the first case, Loretto?
Sir,
Yes, Tyler.
there's 1029, the court says something that I don't quite.
I don't have my book handy, but just tell me what you're looking at.
Yeah, it says physical thing used to possess, use, dispose. To the extent that the government permanently occupies physical property, it effectively destroys each of the rights.
Yes.
What does that mean?
Oh, what a good line you seized upon. Just read it for us one more time, please.
Property rights in the physical thing have been described as the rights to possess, use, and dispose of it. To the extent that the government permanently occupies physical property, it effectively destroys each of these rights.
Okay. The key word in that sentence is effectively, right? Effectively destroy. So has it destroyed the right to? It's use, exclude, use, and expose. Which were the three?
Possess, use, and dispose.
Possess, use, and dispose, right? Think of it this way. There is a strip of land on Loretto's house. Can she put anything else there?
No.
She can't use it. Can she dispose of the wire that's on that part of her land?
No.
Right, she can't dispose of it. What's the other one? I always forget.
You possess.
Possess and use are the same thing, right? In other words, the fact that that wire's there means she can't use it for what she wants to do. She can't exclude people, right? It effectively destroys each stick in her bundle. It doesn't have to actually get rid of it, right? But it effectively destroys it. The reason why I'm harping on this word effectively is in the next case, Justice Sotomayor rewrites Loretto. She says Loretto explains that you have to destroy each and every stick in the bundle. She uses the phrase each and every. And that phrase each and every conflicts with the word effectively in the passage Tyler just read. I'll come back to that later, but the passage you read becomes very significant with the Sotomayor dissent and the Raisin case. But good question. California raisins. Okay. Any other questions on the first case, Loretto? It's an easy case until you actually look at it. I think it's not so easy. All right. Rachel, you want to give me the facts, please, in the second case, Horne versus Department of Agriculture, 2015?
Okay, so in this case, there's the Horne family, which are raisin growers and dealers.
And by the way, raisins are shriveled up grapes, right? The way you make a raisin is by shriveling up grapes. People may not know that, but anyway, raisins don't grow in the ground. They're grapes. So, right, go on.
And the raisin community basically makes all raisin growers turn over a percentage of their raisins each
Okay.
year. And it gets shipped to a raisin handler, and they actually separate the raisins, and then they get paid the remainder, and then they pack and sell the free tonnage raisins.
Free tonnage, huh?
Free tonnage raisins. And so they sent a truck to the
But okay, let me just pause you for a second. I'll come back to the truck in a minute. Why on earth does the government do this? Like, what is this thing that they're doing? Why are they doing this?
I would say to get a cut of their profits.
You're smart. But Rachel, you're a government lawyer, right? You'd say it's like we're trying to steal money from the raisin growers. Now that's not what we tell the court. Why does the government establish this policy? If you're the government, what's the rationale behind this policy?
Maybe to like regulate or maintain the market.
Okay, good. Specifically, what are they trying to do to the raisin market? I think you're almost there. Why would the government do this? By restricting supply, by taking raisins off the market. What happens when you reduce supply?
To fluctuate the supply and demand,
Yeah, when you reduce supply, what happens to the price?
then it goes up.
Bingo. This is a scheme designed to stabilize market prices, which means keep prices artificially high. I'm sure in common law you studied a case called Wickard versus Filburn, right? Farmer Roscoe Filburn. This was a case about wheat and whether the federal government can punish farmers who grow too much wheat on their land. Now, this was a case about whether Congress could use its commerce and necessary and proper powers to restrict how much wheat was grown on a local farm. But this regime existed to control the prices. The idea was if people are growing too much wheat, the price of wheat will go down. And if the price of wheat goes down, farmers will suffer. So how does the New Deal government try to help farmers? By raising the price of wheat. Screw the consumers, right? They don't matter. But let's raise, sorry, I cross the line every now and then. But if you raise the price of wheat, the farmers will be better off. This sort of agricultural marketing scheme still exists in the year 2000, at least 15. It still exists today. The government would decide how much raisins could be grown in a given year. And any raisins grown in excess of that amount would be turned over to the government. The government would then sell the excess raisins, perhaps on the international market, so as not to affect prices domestically. And the raisin growers would be then paid for the excess tonnage of raisins that were then put to the government. Indeed, the government would show up with a truck, I think Rachel was about to say, and basically take the excess raisins and put them to this international market. Now, in some years, the raisin growers would actually benefit. Maybe if there was a very weak crop, they would make more money, or they might make more money from this government program than from selling the raisins in the marketplace, right? But this cartel only works if everyone plays game, right? If everyone plays the game. The Hornes did not want to play the game. They did not want to turn over their excess raisins. They said, if we have all this crop, we had a good crop, a bountiful crop, we must have had good weather, whatever it was. We want to be able to sell this on our market and make our own profit. We don't want to have to rely on whatever rate the government sets for us, right? So they refused to hand over the raisins to the truck. Tell me, what happened when the Hornes refused to hand over their raisins to the government?
The government
Fined them. How much?
$480,000.
Oh my God, yeah, that's a lot of money, right? I mean, that's a lot of money. They fined them almost $500,000, which was equal to the market value of the missing raisins, as well as penalties of another $200,000 because they disobeyed the order to turn them off, turn them over. Okay? Now, tell me, what did the Hornes do to challenge this assessment of the penalty?
They sued them, and they argued that it was uncompensated.
Okay, very good. Thank you, Tommy. Okay, so here's a case, right? The government says, no. We are exercising our police power, right? And pursuant to our police power, we can promote the public welfare. How? By stabilizing raisin prices for everyone. And the way that we stabilize raisin prices is by doing this entire excess tonnage scheme. The Hornes say that's nonsense, right? This is Loretto, right? This is a permanent physical occupation of my raisins, right? You are taking my raisins, not temporarily, permanently. And then you're giving me something, but it's not just compensation, right? You have to pay me. And you're then, you're then penalizing me for taking my property. Just think about it for a second, right? The government said, give us your property. They said, no, fine. We'll give you a fine for not giving us your property. So they were very pissed. Yeah, they were not happy. There were actually 2 Horne cases. This is Horne number 2. The first one went to the Supreme Court in 2013 or so. The court suggested that the government was screwing up, and then the Ninth Circuit ignored it, and it came back a second time where the court resolved it mostly. Whenever you have a decision by Chief Justice Roberts, it's going to be unsatisfying. This is another one of those. It always leaves me wanting more. And lots of very bad raisin puns. Fruitless, my God. It's just. I think the Thomas opinion said this was a fruitless exercise. They sound good when you write them, then years later you get tired of them. Okay, so they sued and they argued that there was a taking of their raisins. Okay, the first question is actually fairly easy, right? Does Loretto apply to personal property as well as real property? That is, Loretto applied to a physical piece of real property, a house. Here we're talking about not a house, but personal property like raisins. Natalia, does the takings clause, does Loretto apply to personal property? Okay, it does. Why?
Because the takings clause provides that it applies, the government shall not private property shall not be taken for public use without just compensation.
Very good.
The important part there is private property.
Personal property, I mean.
Yes.
Right, but we're talking about personal, which is raisins. Right, okay, very good. The court says there's no reason to exclude personal property from this framework. And there's a long history of the government protecting personal properties, such as crops. So the first question, I think, is actually fairly straightforward, right? The second one is actually a little more difficult, right? Okay, name tag, sorry. John, it's fine, you can get it later. John, let me ask you this question. There is compensation in this regime, right? And in fact, what they're being compensated is the market value. This is like the $1 payment in the cable case. Does the fact that they're getting the value of their raisins later eliminate the the takings issue in this case? What does the chief say?
No, because for one thing, they said that it could vary from year to year. And
Very good.
The actual value might not be compensated for, and but they said it's a direct appropriation of private property for government use, and the government is getting all the proceeds from it.
Very good. The question here is not whether they're getting paid eventually. The question is whether it deprives the owner of the use of their property, right? The fact they may get paid for it later is irrelevant. Here, there's a physical surrender. And with that physical surrender, they lose all their rights to control how the property is being used. Maybe they don't want to use the grapes maybe they don't want to use the raisins for one purpose. Maybe they want to make wine out of them. I don't know. Maybe they want to make raisinets or something else. I don't know. You can be creative, right? Maybe they want to use the raisins. Maybe they want to store them for next year when there might be a famine. Who knows, right? 7 years of whatever. Right? They may want to use the crops for later. Because they can't do that, this sort of contingent future interest, if I may, in the raisins is not good enough. Okay? So then we get to the third question, right? And the chief asks, is this a per se taking? When you see the phrase per se taking, that means categorical, right? Per se means like automatic. There's no balancing. So whenever you see the word per se, just think of categorical. I think you'll be in a better place. All right, so Ben, is there a categorical? Is there a per se taking here? Okay, tell us why.
Because it's pretty inherent that they're taking these people's grapes and raisins that they grew themselves that belongs to them, and they're taking them, and it's kind of an inherent, not injustice, but like a barrier.
Yeah, but why can't these farmers stop growing raisins and grow something else? Wouldn't that be one way to get around this taking? They stop growing raisins, they don't have to be subject to it. Yeah. Roberts had this one line, let them sell wine, right? Let them eat cake. The fact that they can make a different crop doesn't take them out of the confines of Loretto. That we have here per se categorical regulatory taking. You see what I did there, right? It's not just a categorical regulatory taking. You'll sometimes see per se categorical regulatory taking. Like you have the same concept expressed with different ways. So this here is regulatory taking. Then we get to the last part, Trevor, on compensation. This is sort of a weird part where the opinion splits a bit, where Breyer and Kagan sort of jump off. What does the court say the compensation must be in this case?
The court says that they must have just compensation for selling raisins.
Okay, and what's that? How do you calculate that compensation?
Market price.
And how do we know what the market price is? We actually have some evidence about that. Right, but we know what that number is. How do we know what that number is, or at least have a guess about what that number is? Close enough. The government had an estimate what the price was. That's how much they were going to give them compensation later. In other words, whatever government was going to pay them later, that is a just compensation. And they also relieved them of the obligation to pay the fine, which I think was easy. Now, in Loretto, we had a situation where the court remanded to decide what the price is. Anyone want to guess why the court didn't remand here again to decide what the price is? Roberts hints at it at the very end. Why did they send this back down to the Ninth Circuit to decide what the price is supposed to be? Yeah. Well, yeah, that's for sure. But why didn't they remand this one again, just to have the lower court enter in the judgment like they did in Loretto? Because in Loretto, too, they said it was $1. Yeah, Zach?
They didn't want to have like the final say.
They didn't have what?
They didn't want to have like the final say.
Oh, the Supreme Court did have the final say. That's why they didn't send it back. You know what? Yeah. Yeah, just say it. Yeah, they didn't trust the Ninth Circuit, right? The chief didn't trust the Ninth Circuit. They were going to screw it up again. So they just said, it's case been going on for long enough, end it. And they gave them their compensation. And because of that sort of abrupt ending, Breyer, Ginsburg, and Kagan said, no. Like, let's send it back down to the lower court, let them decide. But the majority is like, we're not going to do that again. We've had that. We've had this case twice. We don't need a third time. And it's like, okay, enough for you guys. Very good. You inferior courts. We're done. That's the short answer. All right. Any questions on the majority?
Just like this line.
Yeah. Where's your hand, please? Yeah. Go for it.
Just like this line where he says the government insisted that Horne's turn over 47% of the raisin crop in exchange for the benefit of being allowed to sell the remaining 53%.
Yeah.
That's kind of.
Yeah. Roberts is a very good writer, by the way. He drives me nuts, but he's an excellent writer. He and Kagan are the best writers in the court right now. Gorsuch may be up there, but I'm sure about his style. But Roberts and Kagan, they can write. He drives me nuts, though. Always nuts. If you're not in my common law class, I'm sorry, but if you were, Roberts drives me nuts. All right, Tyler, let me come back to you for a minute, because you asked about this effectively line. Here's how Justice Sotomayor's dissent describes Loretto. Sotomayor says that Loretto requires that each and every property right be destroyed by governmental action before that action can be said to have affected a taking. And then she says, because the order does not deprive the Hornes of all their property rights, it does not affect the per se taking. In other words, according to Sotomayor, the entire bundle must be destroyed. If even one stick is left in the bundle, you don't have a taking. Tyler, is that how you read Loretto?
No, sir.
No, neither did I. That's why no one joins her. I don't know where she got this from. And she uses this language each and every, by my count, at least 10 times. She uses the same language over and over again. You see this opinion, this type of opinion every now and then where a justice tries to reinterpret an old precedent. And I think she tried to make Loretto say something it didn't. This was an 8-1 decision. I don't think it was hard under Loretto. I think the compensation question was much tougher. Whether this was a per se physical taking, they were literally taking the raisins. Perhaps no hammer and nail, but they have a truck and a bucket. I think that's enough. Okay. Questions on the Horne case? It was a fun case. I like this one. Yeah, Trevor.
If they weren't physically taking it, instead limiting the amount of raisins that they could sell, would that still be it?
Well, that's Sotomayor makes this point, right? This is Wickard versus Filburn. Wickard said that the government can punish people who grow too much wheat. So this is the crazy part. Had they just fined the Hornes for growing too many raisins, I think it would have been fine. But the fact that they fined them and took the raisins is where they ran afoul of the takings clause, which is almost perverse, right? It'd be better for them to just say, we'll fine you and say you can't sell them, then we take them for you. The action of taking it is where they ran into constitutional difficulties. The government just said, we're going to fine you and say you can't sell them. I think that would have been okay. And so Sotomayor goes, how can it be that we can tell them not to sell the raisins, but if we take them and pay them for it, it's not okay, right? Farmer Filburn got screwed. He got nothing. Here the Hornes are getting a lot of money. So this is why I think Wickard's wrong, but you know, it's too late for that to be said. Wickard was wrong. Okay. Any other questions on raisin case? All right, Zach, let's bring us home. The last case we have today is Hadacheck. It's an old case from 1915. And our struggle will be to reconcile all these cases together. What you're going to find is that a lot of these cases don't seem to line up. Loretto and Horne, I think, are more or less on the same page. Maybe a little difference here or there, but they line up. Hadacheck seems to go in a very different direction. So you want to give me the facts, please, here, Zach?
So in this case, Hadacheck, he bought this piece of land, super valuable land, and he started using that to make high quality bricks.
Uh-huh.
And then, after that, so it was worth a lot more for making bricks, and it wasn't worth that much as residential property.
Uh-huh.
And Los Angeles ended up acquiring that land. And
Good.
asking buildings that he could make bricks in.
Okay, very good. Could he dig the clay up?
Yeah, but he couldn't burn it.
Bake them. Yeah, very good. So everyone understand how bricks are made? Maybe you don't. Clay is taken from the ground. It's kind of soft and mushy. And then you put the clay into these like molds. And then you actually bake the clay like in an oven type situation. And when the clay hardens up, that makes a brick. Okay. So Hadacheck owned a very big brickyard in California. The land was quite valuable. It was worth $100,000 an acre. And I did the math. In present day values, it was like about $20 million of land. So, I mean, we're talking about a substantial amount of money. And the way it works is you excavate, you dig up the clay from the ground, and then you bake it. It's possible, of course, to perhaps dig up the clay in one location, then transport the clay and bake it somewhere else. That's very expensive, right? The most effective way of doing it is baking it right away. Also, when the clay is out of the ground, it hardens up and becomes hard to transport. You have to keep it moist. You know, there's all these things you have to do. The city of LA enacts an ordinance that makes it unlawful to operate a brickyard within city limits. Of course, when he first started this business, he wasn't in city limits, but the city of Angels grows and grows and grows, and you know this eventually comes to him. Think of like the coming to the nuisance case, the Del Webb, the Spur Industries versus Del Webb. It's kind of like that, where he was operating his business just fine, and then the city sort of grew around him, and then he was now in city limits. The city then prosecutes him of a misdemeanor of operating this kiln, these brick ovens, without the proper authorization. And the plaintiff says, look, my business is not a nuisance, right? It doesn't create any noise, doesn't create any odors, there's no smoke, or very low smoke. We've had no complaints in years, right? You are depriving me of my property. You are taking my property without just compensation. Okay, that's Hadacheck's argument. Alyssa, how does the city respond to these claims?
They say, or they deny that, and
Well, did the city think that in fact there was a common law nuisance?
Yes.
Okay. Why? What about this business created a common law nuisance?
Because it violated the ordinance.
No, I know it violated the ordinance, but why was it a nuisance? You're answering the question with the question, right? Why was there a nuisance? Why did it violate the ordinance? What about the brickyard was dangerous?
The fumes and gases.
Yeah, that's what I'm looking for exactly. There were fumes, gases, smoke, dust, debris, these sorts of things. Hadacheck said that it was minimal, but generally the government can define nuisance quite broadly. And even if it's only a little bit of smoke, that's still a nuisance of a small degree. Okay, so Jennifer, when the government is regulating or prohibiting a nuisance, is that a taking of property?
No.
What do you call it? What do you call laws that prohibit nuisances? It's not a taking. What is it?
Police power?
Bingo. And when there's a police power regulation, Jennifer, is there a requirement to pay compensation?
No.
Okay, exactly right. The court says that the police power is like one of the most essential powers of the government. And the city must have flexibility to deal with expanding industrial conditions. This might remind you of the Village of Euclid decision. It's a similar type language. When you have these cities that are sprawling out, the city must have the power to restrict their uses. The court says there must be progress. And if in its marked private interests are in the way, they must yield to the good of the community. My goodness. Right, it's from a Bernie platform, right? But this was the court in the early 1910s. Bizarrely, the majority is by Justice McKenna, who joined the Lochner majority. Don't ask me that one. But they at least were okay with this sort of restriction. As a result, the court says that this is an exercise of the police power. In other words, if an action is about controlling a nuisance, a common law nuisance, it's not a taking. Right? And this creates this sort of exception that if the government is trying to prohibit a common law nuisance, there's no taking. The difficulty then becomes what kind of land use regulations are actually policing common law nuisances. And we'll come back to that, I think, not next class, but the class after that one. All right, so with me so far? All right. Let me try to summarize a bit because we've covered a lot of ground today. When you are looking at a takings case, you generally have two different doors. The first door is what's called a categorical or per se regulatory taking. This is the hammer and nail approach. When you have a categorical per se regulatory taking, you have to pay compensation. There's no ifs, ands, or buts. There's no negotiation about it. Then you have some cases where you have a balancing test. That's our readings for Thursday, right? Where the government's not actually hammering something to your land, but they're reducing the value. Think of like the flooding cases. And when they're reducing the value, there's a balancing test that applies. And more often than not, no compensation is provided, right? So here's the upshot. With these per se takings, you always have to pay. And with these balancing takings, you almost never have to pay. As a result, property owners try to get into this first category, and government's trying to get into the second category. But Hadacheck gives us a sort of an exception, which is using the police power to eliminate common law nuisances, right? That's Hadacheck. And when using the police power to eradicate common law nuisances, there's no compensation ever. Even if the law diminishes the value of property, there's no compensation. Think of Mr. Hadacheck. He had a $20 million lot. Now it's worth zero. Well, maybe not zero, but close to zero. You can't make bricks on it anymore, right? When you have a nuisance to be abated, you apply the police power, and there's no compensation. You may say, oh my God, Josh, are these three categories? Just you wait, my friends, just you wait. There are a lot more categories. But at least try to keep these three settled for now. Okay. Questions on Hadacheck? All right, I will see you all on Thursday. Thank you so much.